as a starting point, let's talk a little bit about the conflict of interest as one of the key points for professional conduct. Oli, if you could a little bit tell us about the conflict of interest, how it can come up actually in the actual practice, and what we need to consider in order to decide if to proceed with a particular client or whatever the matter.
Conflict of interest is actually a fairly dangerous professional point, which is why when you go into practice, one of the first things you'll do actually is to enter people's names into a case management system and see if it flags anything up. The actual risk is that you breach not only some of your own principles that we have to comply with, but also specifically what we're looking at here, 6.1. You do not act if there is an own interest conflict. So if you personally have an interest in a transaction or something that is proposed, you or your firm, or a significant risk of such a conflict. And 6.2 as well, if there is a significant risk of a conflict in a situation where you don't have any of these things that apply. So we'll see actually an example of this today, where we're going to talk a little bit about this and go through a scenario. But normally, and in our scenario, it would be relatively clear if there's a conflict of interest. If there is a competing interest, you can say that there's likely to be a conflict. If you have, for example, two parties in litigation, obviously there's going to be a conflict. They don't want the same thing. They're competing against one another. They're not competing for the same objective. They're not working together to, for example, facilitate a transaction where everyone wants the same thing and there's no longer anything to be negotiated. So that's the first thing that I would say is we need to identify firstly whether there is a conflict, whether it's a conflict between two parties or a conflict that we ourselves might come into or which even our firm might come into. And then we can look at whether or not there's any kind of applicable exception to that. What we have here in 6.2 is where we have a substantially common interest in relation to the matter or an aspect of it, which would be an example I'll give you here, where you have two parties that are both working together as buyer and seller, perhaps. Now, normally you would say, okay, that's a conflict of interest. They don't necessarily want the same thing. They are perhaps competing for the same objective, but there are things left to be negotiated. Maybe there are some issues with the title. Maybe we want to negotiate a price reduction, things like that. In some circumstances, it may still be safe to act where, for example, we don't have any of those issues. If we exchange contracts at an auction, everything's already been agreed. We're just dealing with completion. Even though we might be acting for both sides, we're competing for the same objective. We have a substantially common interest. There's no longer a real risk of conflict. Now, in that situation, we still need to comply with these other provisions in 6.2b. We need to make sure that we have informed consent, and we need to evidence that in writing as well. So the firm that I'd worked for previously, when we were dealing with these kinds of transactions, we would always have a standard form where we said, these are the circumstances. We're making you specifically aware that we are also acting for the buyer or the seller, and we need you to sign this so that we have written evidence that we've made you aware of this and you still consent to it. We also then need to put in place appropriate safeguards. Now, that might be, and another example of this, that might be having different people dealing with it. It's not really appropriate, even in those circumstances, to have one solicitor doing all the work for both sides. So you may perhaps have a physical distance there. Maybe your firm has two offices and you have one deal with buyer, one deal with seller. And then also we need to be satisfied that it's reasonable for us to act.
I would say it greatly depends on the area of practice. As you've mentioned, in litigation, specifically disputes like civil litigation, this is very unlikely because they are competing for the same objective.
I can't see it being appropriate.
In criminal litigation, for example, it can come up in a situation where you can actually be instructed by two co-defendants. But the general rule is that it's very likely that two co-defendants are likely to blame each other in the crime. So in this case, it's possible that we should start acting for both, because it's in the interest of both of them for us to advise right now at this point, but then we would have to cease acting for one of them, or maybe for both of them. Depends what kind of information we obtain, because disclosure and duty to disclose and duty of confidentiality may also knock on the door here. Since we obtain some confidential information from one client, and we have a duty and obligation to disclose this information to another client.